All right, let's jump right into this explainer. Today, we're essentially opening up a lawyer's playbook to see how fundamental rights are actually enforced in Pakistan. We're basing this whole discussion on an incredibly detailed lecture by advocate Rabia Khan. And look, this goes way beyond theoretical textbook law. We're talking about what happens when the state just totally oversteps its boundaries and how ordinary citizens can actually fight back using constitutional remedies.
We've got a packed agenda today. We're going to cover the context of judicial power, the legacy of Asma Jahangir, the 5 constitutional writs, the rules for maintainable petitions, PIL and suo motu, and finally, wrap up with some crucial advice for young lawyers.
Starting off with Section 1, the context of judicial power and the reality of enforcement. You know, to really grasp the law, you've got to understand that courts in Pakistan, and honestly anywhere in the world, do not operate in a vacuum.
There's this brilliant quote from Justice Stephen Breyer that hits the nail on the head. He basically points out that courts lack physical force. In Pakistan, it's often said that the courts don't have a banduk, a gun. They don't have their own army to force compliance. So, if the executive branch just flat out refuses to enforce a decision, what can the court actually do? Because of this reality, judges often exercise a lot of restraint. They might avoid a legally perfect ruling if they know it's just going to be ignored, because non-enforcement leads to anarchy and completely tanks the court's legitimacy. You literally always have to look at the political era a case was decided in to truly understand the outcome.
So, what does this all mean for us? Well, we have to ask who actually needs these courts the most. A super wealthy or highly connected person? They can usually maneuver their way out of a jam. But a garib, a poor person, a non-Muslim, or someone facing systemic discrimination? They are the ones who take the biggest hit when fundamental rights fail. Enforcing these rights is absolutely crucial for protecting those who can't simply buy their way to justice.
Moving to Section 2, the legacy of Asma Jahangir and defending the vulnerable. History shows us that during periods when rights are brutally suppressed, champions kind of just emerge out of sheer necessity.
Take the 1980s under General Zia-ul-Haq, for example, when fundamental rights were heavily restricted. It was in that incredibly hostile environment that Asma Jahangir, affectionately known as Marie Laswa, really stepped up. She founded AGHS, fiercely defended women and victims of blasphemy accusations, and later became this towering figure in the lawyers' movement. She recognized a hard truth: the defenseless need specially created legal avenues. And her philosophy basically laid the groundwork for modern public interest advocacy in Pakistan.
All right, Section 3, the 5 constitutional writs under Article 199. Now we're getting into your actual legal arsenal. This is the High Court's extraordinary jurisdiction. And highlight that word, extraordinary. You only pull these out when absolutely no other legal remedy exists.
The first and probably most famous writ is habeas corpus, which literally translates to produce the body. This is an absolute lifeline in missing persons cases. What's super unique here is that you don't even need to be the victim to file it. Literally anyone can step in on behalf of someone unlawfully detained. You file the petition, the court issues a notice, and the detaining agency has to either justify why they have them or let them go. There's this stunning historical example from 1984, the Darshan Messiah case, where bonded laborers to send a simple telegram to the Supreme Court complaining about being detained. And get this, the court treated that informal telegram as a valid habeas corpus petition.
Next up is mandamus, meaning we command. You use this writ to force a stubborn public authority to actually do a legal duty they're ignoring. Say you're trying to force a development authority, like the LDA, to issue a license they're legally supposed to give you. But there's a major catch. As the Zain al-Abidin case showed us, you can't use mandamus for purely contractual obligations. And importantly, you can't use it against private entities. You can't just file this against a private university like LUMS, unless they are performing very specific state functions.
Then we have prohibition, or we forbid. Think of this as your preemptive strike. You file this to stop a body from doing something imminent that totally exceeds their legal jurisdiction. For instance, if a provincial ombudsperson is about to hear a cross-province harassment case that legally belongs at the federal level, you'd drop this writ to stop them in their tracks before the wrongful action actually happens.
Now our fourth writ is quo warranto, which asks, by what authority? This one is incredibly empowering because it challenges a person's right to hold a public office. If an official doesn't have the right qualifications, has a criminal conviction, or their term expired months ago but they're still making decisions, any tax-paying citizen can file this. You don't even need to be personally aggrieved. You're just stepping up to make sure public offices are held lawfully.
The fifth writ is certiorari. While the previous ones look at future actions, this one looks backward to quash a past decision. If a lower tribunal made a call that was infected by bias, denied you a fair hearing, or made an obvious error on the record, you use certiorari to undo it.
It's tied to the power to declare an act ultra-virus, meaning completely beyond legal authority. A really fascinating current example is the pending challenge against appointing retired PCO judges to election tribunals. The whole argument is, if their original appointment was void, they can't legally be considered retired judges at all.
Section 4. Rules for maintainable petitions. Having a constitutional weapon is totally useless if you don't know the rules of engagement. Getting your writ actually heard in court, making it maintainable, requires passing some strict technical tests. First, you absolutely must establish locus standi. That means you have to be an aggrieved person directly impacted by the issue. Take road closures during a big PSL cricket match. If you live 10 miles away and you're just annoyed by the traffic, you don't have locus standi. But if you own a local business on that specific street and are actively losing money because customers can't reach you, boom, you have locus standi. It has to be a direct, tangible grievance. Next is the doctrine of laches, which is really just a fancy way of talking about timeliness. Even though Article 199 doesn't have a strict statutory countdown clock like civil suits do, you can't just sleep on your rights. If a government agency wrongs you and you wait an unexplained 5 years to file a petition, the court is going to look at you and say, "Why now?" And they'll likely throw your case out under this doctrine.
Also, who can you actually sue? Article 199 is generally meant for public bodies. If you're trying to sue a supposedly private organization, you have to pass the tough 3-tier conjunctive test, famously laid out in the 2010 PIA versus Tanvir case. You have to prove 3 things: that the bulk of their funding comes from the state, that their functions are tied to sovereign power, and that the state substantially controls their governance. If you miss even one of those points, they aren't a valid respondent.
Section 5. PIL and suo motu under Article 184.3. Now, this explores a completely different path. Sometimes the Supreme Court just bypasses the high courts entirely and uses what's often called the nuclear option under Article 184.3. This is the realm of public interest litigation and the famous suo motu notice, where the court initiates a case all by itself.
And this brings us to a really fierce debate over judicial activism. And I'm not taking sides here, but just look at the contrast. On one hand, courts have used suo motu to step in where the executive branch completely failed, like fixing miserable jail conditions for women or tackling the tobacco epidemic. A lot of people applaud that. But on the other hand, courts have also taken notice of regulating racing cars or fixing a single bad road outside a court registry. Critics argue that kind of overreach turns unelected judges into a super executive branch. It's a highly debated topic for sure.
Finally, Section 6, Advice for Young Lawyers. As you prepare to step into this complex arena, Advocate Rabia really emphasizes that Article 199 isn't the only game in town. There are other incredibly important forms. You've got election tribunals, the Women's Ombudsperson for workplace harassment, the National Commission for Human Rights. You really need to know these exist before you just run straight to the High Court.
In fact, to be a really effective constitutional lawyer, you've got to practically hardwire these 3 questions into your brain. 1. Exactly what legal right has been violated? 2. What specific remedy exists for that right? And 3. Is there an adequate, efficacious alternate remedy available? You have to rigorously run through that checklist, because if a perfectly good alternate form exists, like an internal departmental appeal, you simply cannot use Article 19.
Let's wrap up with this thought. The legal landscape is never static. We are rapidly moving beyond old property and administrative disputes into entirely new frontiers. Deep fakes, massive data privacy breaches, the right to be forgotten, complex cyber rights. As these new threats emerge, how are our historical constitutional tools going to adapt? The ultimate question is, whether you're stepping into the legal profession or you're just an informed citizen, will you be the one to creatively wield these remedies to protect the vulnerable in our rapidly changing digital future? Think about it. Thanks for joining this explainer, and keep questioning.